Dear participants, dear friends, I propose that we now start this global digital encounter of the FIDE Foundation and the Transatlantic IP activity, and at the same time, first webinar on the EIPTN working group on art copyright, headed by Professor Ulrika. This is for the first time a joint activity. FIDE, the Spanish Foundation, and the Transatlantic IP Academy have decided to pool their forces exceptionally with the EIPTN, the European Intellectual Property Teachers Network, to offer you a very special 27th Global Digital Encounter on IP and Museum, and first webinar of the working group on arts on IP and museums. So why pooling our forces? Because we thought that we want a very expanded public for this activity, public of academics from the European continent, public of academics from all over the world, public of professionals, senior students, and interested person in this very important topic. Indeed, IP is key to the museum. The museum cannot live with IP. From the IP rights attached to artworks, to digitalization of works of art, to digitalization of collections, to issues connected with the relation between the museum and its public, its consumers, with art merchants. IP is at the heart of the museum activity. This is why we decided to dedicate this expanded global digital encounter. Co-directors of the GDE, Professor Manuel Desantes and myself, the academic coordinator, Professor Javier Fernandez Taschetti, we all decided that time had come to pool forces with the IPTN to make a very special activity so that you can enjoy the wealth of knowledge of our experts, all responsible of activities at the European Intellectual Property Network, and for all of them working on the issue of intellectual property and museums for many, many years. It is a very special honor to greet all of them. Professor Wennersten, of course, the chair of the working group of the IPTN on this topic, Professor Yolanda Berel-Sainz de Baranda, who is also super active in this field and teaches art law, Professor Haris Arzic from Bosnia and Herzegovina, who is super active also in this topic, and modestly myself, who will be in this very group to present our ideas, reply to our public's view, and continue to interact with all of you on this very topic. So there is time for presentation, as usual in the Global Digital Encounter, time for questions from you afterwards, and also at the end of the Global Digital Encounter, we shall issue, as we do systematically, a written report, including readings, so that our audience has a scientific basis to continue the discussion we are drawing today together. I wouldn't wish to keep the floor longer. I would wish to give the floor to Javier Fernandez Taschetti, the coordinator of the project. Javier, the floor is yours.
Thank you, Laurence. Just a few words. Because I think that all our audience is very interested on the topic and is excited about it and anxious to hear, as I am. It's a different view of the museums. We'll walk around, we visit museums. I'm a supporter of El Prado Museum, for instance, but this is a different view, and it will be very interesting. I'm very happy to be here to learn from specialists, and just remember that we belong to a community. And please raise questions, share documents, share ideas, etc. Thank you very much. And Ulrika, the floor is yours.
Thank you so much, and welcome all. today we have tried to divide, we will try to divide the discussion into different kinds of topics, because when we're talking about how important IP is for museums, we firstly want to talk about museum as users, then we will move on to museum as creators. After that, we will look at museum and the public, and also museums as leverage in using museum IP as leverage in negotiations. And finally, we will talk, as this is a joint event with also the EIPTN, we will talk about how we actually are using museums in our IP teaching, or how one could use museum in IP teaching, and give some examples. So we will move then to museum as users of work, and I will raise the questions to you, Yolanda. What kind of IP issues should museum actually consider when they are, for example, buying or lending or receiving work? Can you say something about these kinds of IP questions?
Yes, of course, Ulrika. Thank you very much. Well, thank you very much, EIPTN, for the invitation. And I'm really happy to work again with FIDE. I have participated in different activities, but never in the Global Digital Encounter. So I'm very happy to be here. And yes, as Ulrika was saying, museums are users of works protected by copyrights. Not only they display the works, but they also reproduce the works in their catalogs. They reproduce and distribute the works through merchandising. And nowadays, they digitalize the works. And that entails reproduction. And if uploaded and made available to the public, it will entail an act of communication to the public. So therefore, it is key for museums to know which rights they hold over the works, over each of the works in their collection, in order to make an appropriate use of the works in compliance with the rights of the artists over their works. But this diligence has to be exercised not only with regard to the works already in their collection, but also when buying works of art. When acquiring new works of art, it is necessary for museums to think in advance, to think ahead, in order to require the rights or authorizations necessary to carry on the museum's activities. This because the buyer of the work does not have any copyright over it, unless otherwise provided by law or by the contract. Because, for example, in countries where the first sale rule applies, the owner of the work acquires the right to exhibit it, to display it, unless excluded in the contract. But if the owner wants to make any other use of the work, then the assignment of the right or the authorization of the right holder is necessary. As I mentioned, nowadays, not only the reproduction and distribution rights are key for museums' activities, but also in this age of digitalization, the right of communication to the public is also capital for museums. Still, the art market is very informal in its functioning, and contracts of sale, if any, because sometimes the buyer is only given an invoice, contracts of sale are very brief and may not address issues relating to copyright. In order to make things right, the contract of sale should contain a provision allocating to the museum the author's rights that it might need in the future, but also the scope of those rights, if they're exclusive or not, duration, territory. And these might be easy for museums to do in the case of a primary sale, when the museum is buying directly from the artist, for example. But in the case of the secondary market, when the museum is acquiring from a subsequent buyer, they have to be very careful, because it might be that the seller does not own any rights over the work, and it will have to be searched for elsewhere. And with regard to loan contracts, the idea is the same. If the museum is the lender, it has to be determined whether it can authorize the use envisaged because the museum holds the rights necessary, or whether the authorization has to be searched for elsewhere. with the artist, the heirs, the collective management entity, and so on. And on the other hand, when the museum is the borrower, the holder of the rights, whether it is the lending museum or whomever it is, will have to authorize the uses foreseen. Normally, in standard loan contracts of works of art between museums, the contract provides that it is the responsibility of the borrower to acquaint himself with the necessary author's rights for the intended uses. Thank you, Ulrika.
Thank you so much. You were saying that, you said in the beginning then that they are actually reproducing the work and so forth. So they are actually also creators of works, then I assume, as they maybe are doing reproduction, they are making available to the public and so forth. But can you say something more? Because I'm thinking of course, my best hobby is actually to go to museum shops.
I love museum shops too. Well, yes, of course, museums are not only users of works protected by copyright, but they also create works which might be protected by copyright. And this is extremely important from museums nowadays for very different reasons. On the first hand, as you were saying, they have people like you and me, and it's a great source of income from which they can finance their activities. But also, in this age of digitalization, it's very important in order to promote the collection because of the exponential increase on the possibility to spread information. Museums are having great success with the content on their social networks. For instance, the Prado Museum, it's very brief, every single morning Instagram, it's having a big success. Or in the contents they upload on YouTube. If you have a look at the Prado Museum YouTube contents, literally makes you want to go to the museum. So it's a way of promoting also the collection. And if it's properly done, it reinforces the prestige and the reputation of the museums. So let's think of some examples of works that museums create, which might be protected by copyright. For instance, we all think of the photographs of the works in their collection. As we have mentioned before, to take the picture of the works, they will need the reproduction right. But once they have it, the photograph can be protected either by copyright, if original, or by related rights in countries where such protection is granted to non-original photographs. It is true that in this field, it is difficult to decide whether a photograph is original or not. And in this regard, the views of common law countries and civil law countries might be a little different. But in any event, once taken, the photography might be protected. Of course, if the photographer is not a museum employee, then the use of such pictures will need the consent of the photographer. In this regard, a small caveat with as far as work falling into public domain is concerned, because these works are no longer protected by copyright or any related rights, because the copyrights over such works have expired, and therefore museums can use them freely, but they cannot impede the use by third parties. This is the spirit of the European Commission's policy on access to cultural objects in the public domain and of Article 14 of the Digital Single Market Directive, according to which any material resulting from an act of reproduction of works in the public domain, it's not subject to copyright or related rights unless it is original. So we can think of photographs. We can think of catalogs that the museum publish, or guides of their collections with photographs and texts about the works. Again, if the experts writing about the works are museum employees, the museum, it's fine, but if not, they should have to conclude a contract in which they assign the rights to use those texts or pictures to the museum. But museums also issue multimedia products with music, comments, photographs, videos, etc. And they will also need the assignment of the rights of the different participants in the product, if the museum is the producer of the multimedia product, which is the case more often nowadays. For this purpose, as we already mentioned, the works have to be digitalized. And digitalization entails an act of reproduction, again, because there's a change in the medium of the work. And then the commercialization of these multimedia products might take place offline through CD-ROMs, DVDs, although I probably think that I'm the only person in the world who still buys DVDs. That will entail an act of distribution, or the commercialization might take place online, in which case uploading the product gives access to it without the distribution of copies and constitutes an act of communication to the public. Museums also carry out merchandising. They reproduce their works in notebooks, scarves, umbrellas, and many other objects. Same ideas applies. In this regard, I'm only going to say that sometimes museums commission a third party to do the merchandising of their products, and therefore they would have to sign a merchandising contract necessary to authorize the use, define the object, the means of use, the quality of the products. Say they will require sometimes sample approval, etc. And finally, I can think of another copyrighted work created by museums, which are the exhibitions that the museum organizes, because the design and expression by which the curator, I'm thinking about the selection of works, the way in which they're displayed in the exhibition, the design of the panels, the text on the labels, and all this combined might be considered an intellectual creation, and it would give rise to author's rights, or it might be granted the protection of related rights. You could think of maybe a protection similar to those granted to stage directors. Again, if the curator does not work for the museum and the curator should conclude a contract assigning the necessary rights over the exhibition. So yes, museums are users, but a very important tool in the hands of museums is that they also create works protected.
And that is very interesting that even the curators actually can produce works in themselves. So as you said, of course, that is of importance to know if they are employed or if they are only on a contract, because it could be different in different jurisdictions also when it comes to who's actually owning the copyright and so on and so forth. So that is really interesting. But I'm going back to my shop, as I love the shop. So now I wanted just to ask you also, Laurent, if you want to add something on this act of, because it seems like today, of course, we're all living in this digitalized world. So we firstly, what do? We Google the museum to see what kind of collection they have and if it is actually, if we should go there and so forth. And when we have been there, we go to the shop and we buy some stuff and so forth. So I'm also interested, is it only copyright we have to think of in this case, or do they also maybe use other kinds of IP? Do we know that?
Well, thank you very much, Ulrika, for this question. I think the issue of the museum going out of the museum is absolutely key to our discussion today. Basically, let's take the reasoning for it. The museum needs a larger public. Why? Because we are in a globalized world, A, and B, because it helps them having visibility. So they are together users, creators, as you have mentioned, And digitalization is at the heart of their activities, so that not only the issue is not only growing, but is also avoiding to die in a world that is heavily digitalized. So you need the visibility. And this means that you wouldn't use, as a museum, only copyright as being the key IP tool. This is the central IP tool. There is no doubt. Museums live thanks with and in an uneasy osmosis with copyright, as Yolanda has just described. But this goes far beyond, in the sense that they need trademarks that they will use in particular for the domain names that they need to develop to have visibilities. So they enter into the trademark also for the merchandising that has already been mentioned by Yolanda. They use industrial designs in many aspects of the way they display their collections. They are also artwork makers and designs makers. So they are users and makers. And this brings several legal issues that are not limited to the field of copyright, though often copyright-centered. So on trademarks, the issue is connected very much with the relation with the domain name, the merchandising. On industrial design, in some other aspects of museums' creativity. In copyright, the digitalization, which is needed and at the same time difficult to handle, permits immense possibilities for the museum, possibilities that challenge IP, and at the same time bring several limits on museums' activities. So possibilities. For example, the museums can watermark the works, or the artists can watermark the works, which means that when they circulate, they are safer. Museum exchange also between themselves works for exhibition, which limits also some transmission and circulation of the work. So it's double-faced, but the watermarking is something very useful as well. There I'm talking of the museums, of course, that have the traditional collections, but there are also museums nowadays that display non-material collections. And this is even more complex there. There is, of course, the issue of the management of rights that the author of a work may impose that be present to the museum, so that some derivated uses may not be made by the museum. So this renders the work of the museum far more complex. So the museum is now taken in the middle or in the picture of digital rights management option. And self-evidently, the museum leaders are normally curators, conservators, who are not in this business, in this job of IP. So they need help, a positive help. They need to be cautious at the same time. They are offered commercial services to perform this task of digital rights management, which is a marvelous challenge for them to get more resources, but also this has drawbacks. For example, it is very beautiful that Google permits that the contents of many museums be visible, and at the same time, once it scans all the collections, it may offer commercial services out of it. Is it good? Is it not good? It is something fascinating and something deeply needed. And this is why Google made arrangements with so many museums for digitalization. So as such, this is the issue of digitalization is, if I may say, needed in order to make the museum more accessible. So there is a social function for it. But then it creates a big question, which, by the way, is reflected in the European legislation, which is that everything is on control, is about control. Who controls the digital rights? How is the museum an actor or a victim in this. This is really something where we, academics of IP law, play a key role in advising European authorities, in also teaching to our students on this very, very topic. This is something very complex. But no doubt that this makes the museum global and not only something for art lovers, which I am, but which is only a limited part of population. This is something that can permit the museum to reach all people in all disciplines and therefore be a social tool, which is its historical function that is revived thanks to the digitalization. The museum means bringing culture, knowledge to people.
True. But I was thinking also, because you're talking about digitalization and so on and so forth, when you also go to the museum, you probably would like to take your own picture. I know when I was in Madrid last time, I went to the Prado Museum and taking up my camera, and immediately a person came and said, no, you can't take a picture. And then the question is, how can they actually, I mean, you said about Article 14 and the new, where you actually, if this work has fallen into the public domain, then they can't stop you actually from or you could reproduce the work as long as it's not original. But how can they then stop me from taking a photo? Do you want to comment on that, Jolanda, first?
Yes, sure. That's a very, very good question, Ulrika. Of course, the museums of modern and contemporary art have their own, and particularly they have copyright problems, but museums of old masters have their own problems as well. And as we were already mentioning, for instance, the case of a Prado or museum of any other old masters museum, once a work falls into public domain, the economic right, the copyright of the artist expire, and then it could be freely used by anybody. So, in principle, you could take your picture without problem. The idea is, as Laurent was saying, museums promote public access to culture and to cultural heritage, and therefore, once the work is fall into public domain, then it should be free. Works fallen into public domain can no longer be protected by author's rights or any related rights, and can therefore, for example, be freely reproduced by Ulrika. As mentioned, Article 14, let me have it, of the Digital Single Market Directive provides that member states shall provide that when the term of protection of a work of visual art has expired, any material resulting from an act of reproduction of that work is not subject to copyright or related rights unless the material resulting from the act of reproduction is original, in the sense that it is the author's own intellectual creation. This means that reproductions of works of art in the public domain, which are not original, should not be protected by copyright or related rights. However, this provision does not entail a right of access to the works. For example, a museum is not obliged to facilitate entry to third parties for any acts of use of the work in the collection. For example, museums can prevent, by contract, the possibility to take pictures inside its premises if it's reasonable. I'm thinking of reasons of preservation of the works, for instance, no pictures with flash. At the Thyssen Museum, for example, pictures are allowed but not with flash. So the policy of the museum can differ in this regard. It is true, however, that if the museum bans this possibility and does not grant access to pictures or reproductions of the work, the result is that the public does not have access to the works in the public domain. And this is particularly sensitive, as Laurent was saying, in the era of digitalization of museums' collections. In general, museums upload in the webpage images of the works in their collection, but the quality of those images differ from one museum to another. In some cases, all photographs are uploaded and can be freely used. In other cases, in order to use high-resolution photographs, the works will have to be paid for. And this is understandable because, as Laurent was saying, digitalization of the collections is an expensive procedure. It is true that the European Commission promotes no copyright on public domain works, but on the other hand, it promotes the joint effort of public and private sectors for the digitalization of cultural goods through cooperation agreements, granting exclusive rights for a period of time so that the investment can be recovered. 1 minute. To address the last issue, because this has been very polemic, not only the right of property to the work might limit the access to the works in the public domain. For example, in Italy, the law protecting the Italian cultural heritage, the Codice dei Beni Culturali, provides that some cultural heritage institutions have the right to authorize the use of works in their collection in the public domain and to charge a fee for such a use. And these rules have been recently applied in a very polemic case to prevent a German company to use the image of the Vitruvian Man by Leonardo at the Galleria dell'Accademia in Venice by reproducing it without such authorization in jigsaw puzzles. So this decision has been very controversial because the result of these rules is contrary to the idea behind Article 14 that we were saying, but we will see what the future of this clash brings us.
Oh, that is interesting. So it could be cultural heritage, and it could be also that the curator have their own copyright, and it could be contract. And do you want to say something, add something, Laurent, before I ask Harris also?
Yes, I would just wish to say that this issue of Article 14 and the issue connected with the fact that works have to be of lower quality so that they are not subject to payment of fees shows how the relationship between museum and copyright is complex, because at the end this means poorer output of digitalization for the public, for the European public, for the, we can call it consumer in this case, with inverted commas, and this is a drawback for us. So the need of a relationship with the commercial world is essential, and at the same time leads to be antagonist with the objective of the museum. So this is something very, very touchy that can be seen from a positive and a negative approach. And it is understood that the European legislator has a lot of difficulty, and not only the European one in this respect. It is understandable as well. But there is a contradiction, no doubt.
Yeah, and maybe you could say something, Harris, then, because this is, of course, something that the EU legislator have ruled on quite recently, Article 14, and maybe you could say something about how it is in your country or other
Thank you very
countries.
much. Thank you, Ulrika. Thank you, Laurent, and thank you, Yolanda. And thank you to FIDE for inviting me and giving me this opportunity into the GD project. I just wanted to say there is an excellent book. I forget the name of the person who argued that those people who digitalize sort of public domain works should be given a special right that would essentially grant them control over how that thing is used, how the work is used. And I think that's actually a very good point, because if we want stewardship and if we want public access to these works, we have to reward effort that is being given to these institutions in essentially spending money and effort to bring them to the public. Bosnian law, which is not yet fully harmonized with EU rules, does have specific provisions that say that if you publish a work that is in the public domain, you receive what is essentially the equivalent of economic rights of the author of that work for a limited period of time, which is much shorter than the copyright duration. And then there is also a rule that says that if you produce special editions, which are the result of particular effort and creativity and criticism, you are also given certain rights to these works. So I think that this is what we were talking about earlier, the museums as creators. This would definitely incentivize museums to use which are often very limited funds to invest effort into creating something that they would then be able to sort of recuperate some of that investment in.
Thank you. And then we have also a question that just a clarification. So when I'm then entering into the museum, I probably pay a fee, an entrance fee, and also I get a ticket. So that's some sort of a contract, and it might be in that contract then that I am prohibited to actually take a photograph within the museum, even if it is actually a public funded museum, and even if the copyright has expired. True? Yeah. So that is something that also, I mean, even if there's so a contract can be like a complement, even if I take a photo, they cannot, of course, that will be a breach of contract if I then spread it. It will not be copyright infringement. Probably.
What is important to keep in mind, sorry to jump in.
Yeah.
What is important to keep in mind, of course, we're talking about intellectual property, but there is still this issue of property. Museums often own the physical copy, and they are thus able to limit access to, as Yolanda was talking. We have the example of the Sarajevo Haggadah, which is a very famous Jewish text that has long since gotten into public domain, but the museum is actually trying to preserve it by limiting access to it. And that is enabling the museum to recuperate some of the costs and to essentially sort of direct how this work is being perceived by the public.
Okay, thank you so much. And so I will also, if you don't have anything to add in this part, I will also we will move on to the question if actually museum can use their IP as some sort of leverage in negotiations, if that is a possibility. So to actually use the IP, I think that what we are talking about before, you can of course see that will be a possibility if you have actually some sort of IP over the collection or so and so forth. But maybe you want to add something on that, Harris.
Yes, thank you. As Laurent was saying previously, IP is very much about control. There's often this metaphor that IP is the carrot and the stick. It allows essentially the rights holders to control how certain works are used in many of the ways. I think that this is something that museums often forget, that they can use these rights to essentially help them in negotiations. Bosnian museums often face very big problems, especially the public funded ones, because anything that has the Bosnia-Herzegovina moniker that is supposed to be at the national level is not funded. Some of the museums, to our great shame, will actually have to be closed because they didn't have government funding due to political reasons, which I'm not going to get into here. And I recently participated in a project that brought this into sharp focus. The Museum of Alija Izetbegović and the foundation that essentially founded the museum. Alija Izetbegović was the first democratically elected president of Bosnia and Herzegovina. He was a Bosniak. As you know, in Bosnia and Herzegovina in the 90s, there was a war between the Bosniaks, the Croats, and the Serbs. And he's still a very popular person. So, of course, after he passed away, there was a foundation founded and a museum to cherish and to essentially promote his work and his message and his memory. They wanted to digitalize and then to use and to make available to the public the video archives of the public Bosnian broadcaster of the late president. He died in 2003. And when they approached the Bosnia and Herzegovina Radio Televizija, which is the public broadcaster, they said, well, yeah, we're going to allow this, but we want you to pay a certain amount of time, a certain amount of money, which was essentially exorbitant. And they said this project would last so and so. Essentially, they said no in not so many words. What we realized then, and I was very fortunate to participate in this project, is we have these rights, right? The president, Ali Izetbegovic, when he was interviewed, his speech can be protected as copyright. Speech can be a copyright-protected work. And in addition, as he was speaking, he was performing the works. So he also has the related rights of a performer. And we said, well, why don't we use this right as a negotiating tactic, as leverage in this negotiation? Because essentially, the other side was acting as if they had no reason to acquiesce to the demands of the Ali Izetbegovic Museum. And what we did was we had the heirs, the inheritors, assign the rights to the museum, and then the museum said, well, if you don't want to allow us to digitize these works, and if you want us to pay this amount of money, well, we're going to use our rights and prohibit you from broadcasting these videos in the future. And then they said, well, and this is also an important thing to keep in mind for a museum. They said, well, no, these are news, and news are not protected by copyright. There's a specific exemption to this. And they said, even if it were, we said, no, this is not news. He died 20 years ago. Many of these interviews are from 30 years ago. You can't use the news exemption for this. They stopped being news, and the moment they stopped being news, they became copyright protected. And they said, well, we have this right to inform the public. But the exemption, which was pretty much copied from the EU, that says that it relates to current events. So you can't really talk about current events in this context. And in the end, the museum was able to use the fact that they had these rights to significantly improve their negotiation position. They were placed in a position of power, and then they entered into a mutually satisfactory contract.
So, and this leads me to some sort of conclusion in this part. And that would be, I mean, that it's highly important that for museums, of course, to have control or knowledge about IP, even when they are, I mean, as users of, in the sense that they are buying, lending, borrowing, and so on and so forth, but also, of course, as creators of different kinds of works, or as Laurent said, maybe also when it comes to trademark and design and so on and so forth. So IP is really important tool for copyright in their existing world, I would say. And then I want to move, I will just take one question, and then I will want to move to how we actually can use that museum in our IP teaching, because that's really important also. And the question is, why can't I take picture for my own personal use then? Because we were talking about that it can hinder.
Well, I think, thank you, Ulrika. Harry was clearing that this was addressing this issue as well. The thing is that I think the question is addressed to works in the public domain. In principle, you could, but the thing is that, as Harris was saying, when you enter the museum and you pay your ticket, you're concluding a contract, and that contract is telling you how to behave. And therefore, they might tell you not to take pictures, not even for personal use, because you might be damaging if everybody who goes into the museum takes a picture, in the end, it's a lot of light exposure for the works, and that might be a reasonable explanation. The truth is that normally museums that ban the visitors, the consumers, from taking pictures, upload on their webpage photographs of their works. So the idea is that please don't take a picture, go to our webpage and download the picture of the work you like. It's there for you to use for free. If you want a better picture, I mean, the picture that you're going to download from the page is a very good quality picture, but it's not a high resolution, but it's a picture similar to the one you will get with your telephone. So that's a fair reason.
And you want to comment, Laurent?
Yes, and if I may say, whereas we are constantly arguing that digitalization limits the rights of people, in this very case, compared to the previous situation, digitalization offers a low-quality solution, but a positive one. 30 years ago, when you were visiting most museums, you were prohibited photographing, but you were forced to buy the postcard while going out of the museum if you wanted to have it for you. With this solution that digitalization offers and that copyright law permits, you, as a public, have a right to a low quality image on the web, but still an image without paying. So to a certain extent, this shows the double face aspect of digitalization and the complex issue of the legislator in this respect.
Yeah, and of course, if it's still protected, then we have other problems, because then it will be reproduction and so and so forth. But that's another thing that we can also elaborate on. I just want to say something about IP in teaching also. And I have here in Lund in Sweden, at Lund University, we have a collaboration with, because the university has an own museum of artistic processes and public art. So I use the museum, actually some sort of problem-based learning, where I take the students to the museum, and the museum personnel actually picks out some works, and we have this as a starting point, and we discuss different kinds of IP issues that could be included in different kinds. So it's not really real cases. It's more like you problematize if this can be some sort of IP infringement. But I think this is really interesting way to also use museum in teaching, because here, of course, the student can be inspired. You can actually start a curiosity when it comes to the artist and also about, of course, art in itself. They often afterwards start to research even about the artist, and they investigate and analyze and look at different kinds of roles and so on. So I think this is a sort of like an interdisciplinary method also, because it also, law students sometimes, I don't know if it's only Sweden, tends to be very narrow because they are all almost always only into law, so they don't broaden their knowledge when it comes to art and so forth. But here they are actually, in a sense, forced. They are invited to the museum. They can go there as much as they want to because they have free access as students. They start to be interested, not only because they have to solve the legal issue, but also interested in art. So I think this is a way actually also, when the project is over, they shall also, of course, communicate their findings with the museum personnel, and then they have training also to talk about law to non-lawyers. So that is something really appreciated among the students. And I was thinking, have you some sort of similar, do you also use museum in teaching, or can you say something about the possibilities you see?
Yes, Ulrika, do you want me to jump in? I think what you were saying is extremely interesting, because as we have seen during this talk, museums are so involved with copyright issues from different perspectives that you can learn a lot about copyright from their experience. I run a course in art law in Madrid at Universidad Carlos III, and we do have this practical view as well. So we invite museum employees to come and teach about loans, for instance, their experience on importing and exporting, which also raises these kinds of questions. And this year, for the first time, we are taking our students to a museum, to the digitalization department, so that they are going to explain to them what they're doing, why they started so long ago, how they have done it. And all these things come up because we've seen reproduction rights, but also the different means of reproduction: analogic, digital, electronic, communication to the public, but not only display, also interactive communication, different types of distribution, everything comes up with regard to museums. So it's really a nice way to teach.
Do you want to say something, Laurent?
Yes, I may. And I would take two different approaches. One, which is an inspiration from Harris, and with what he mentioned with the issue of the Jewish Museum of Sarajevo and the conservation of the Haggadah there. There is an issue that in art law that is conservation and that is connected and not connected with IP, which is conservation on the one hand and promotion on the other hand. So, and Harris just paved us the way in this respect. So, when we teach art law, museum law, we see a bit like what is shown in WIPO research studies on traditional knowledge or on public domain works, that there is a part connected to conservation. So I limit, for example, as in the Sarajevo Museum, access to the museum or I limit the access to frescoes or grottos of the prehistoric times because if too many people go in, I destroy them because the air is polluted or whatever. And at the same time, I promote them thanks to IP tools connected to digitalization so that people can see it from outside. So that's one aspect that I would say. So, which is a dual function that digitalization, thanks to IP, offers for society. In the second aspect, I am teaching, I've taught for 2 consecutive years some elements of IP in courses of museology at the University of Quebec in Montreal and in Ottawa. And what we are doing, and what is fascinating, for me at least, is that we are doing with the students there, I accompany them in an art project. They study museology, and they are creating in a North American, very applied approach, they are creating a work of art, very often using much digital tools, and I accompany them in identifying IP issues connected to this creation. So this is much connected to Ulrika's experience in Lund with using the museum as a tool. And as such, they would use, like any artist, they would get inspired by contents of their predecessors. And at the same time, they would bring new contents. And how do they protect themselves? They would enter to a commercial work. They would not enter to a commercial work. So we are bringing all these questions together, which permit to cover the IP, I would say a compendium of IP law that will be useful for their future. And these very practical experiences are extremely useful. It happens that we are many professors of law today, but this makes law accessible also to non-lawyers, shared by non-lawyers, understood by non-lawyers. This is, of course, one of the mandates of IP teachers, so of the IPTN. And this is something that is really beautiful, that we professors of law, we can also teach law to non-lawyers through their own tools and their own creativity. So the museum as a creator, the museum as a place for the public, the museum as a place for keeping culture.
Yeah, Harris, do you want to add some?
Very quickly,
Yeah.
There is a permanent exhibition in the beautiful Sarajevo City Hall of documents from the Hague war trials, and we take our students every year there. And I bring this up because I often tell the students that one of the functions of IP is to control the message. We live in times where truth is often the first victim. We know, the quasi-facts and everything. And I think even in South Africa, they use museums to essentially ensure that the message remains consistent and that the message is preserved. And this is also an important part of what this permanent exhibition does, especially because the issue of genocide, which has been proven by a verdict of the court, is often contentious in Bosnia and Herzegovina.
Yeah, and then I will move on because our time is almost up to actually have some of questions and just one comment firstly, and that would be I think that we have touched upon it a lot during this talk, and that is of course, as you said, Laurent, just a couple of minutes ago, that digitalization of course is also a way to preserve, and also as you said, Harris, preserve actually also a collection. So it's not only a problem, of course, even if always digitalization when it comes to IP can be a problem, that it can actually be really good when it comes to cultural heritage questions for the future. Then, of course, one can add one thing that we haven't talked about. There can, of course, be a problem because we don't know what the future holds when it comes to digitalization. Maybe we can't read what we actually digitize in the future. So the technique can go very fast. So that could be a problem, as we today have some problems with reading old CDs and so forth because we don't have the machines anymore.
I see a question on open source.
I saw that. Maybe museum could adopt an open source model to give more accessibility to some artwork in order to integrate them in a form of digital cultural heritage. Could that be something? I leave the floor open. If someone wants to say something.
I think it's a very, very interesting question. It's a question of policy of the museum. Some museums do. For instance, I think it's the Rijksmuseum in Amsterdam uploads all its contents with all quality. But that's a policy decision for the museum to make. I think in my opinion, it's a very good idea. I think it enhances the reputation of the museum to open entirely to the public. But then there's this question of financing, and I understand how expensive it is to maintain a museum, and maybe as a source of income, it's a very difficult decision to make.
The thing to keep in mind, the thing to keep in mind here is that when it comes to museum works that are still in copyright, one aspect of it, you sometimes can adopt open source standards because you are limited by the licensing that you received the works, the permission to use the works in. So you have to be mindful that sometimes you will have to use DRM, digital rights management tools, that will limit the use. And we're not even talking about the up and coming things such as museums in the metaverse or museums regarding NFTs, where we're going to have to be very mindful of if using open source might be problematic for or be even contrary to IP.
Thank you so much.
If I may, I totally share the views of Harris and of Yolanda. The thing is that also the open source development is maturing fastly. So today it presents the drawbacks that have been underlined by my two colleagues. Perhaps tomorrow we have a better maturity that permits still due commercial, let's say, due funding to open source models. Question mark. This is what I wish to say.
Yeah. Thank you so much. I think that we could continue to talk a lot about this because it's, of course, we could talk about also other kinds of IPs, and we could also, I was thinking about the EFTA Court decision when it comes to the question of possibility to trademark sculptures and so forth. So there's a lot more to say about it, but sorry, the time is up, and I will leave the floor to Professor De Santis to close this session.
Yes, thank you very much, Ulrika. Thank you. Wow, this was powerful. Yeah, what an exciting topic. as you all have highlighted, I got the conclusion that the museums cannot work without IP. You know? But also that intellectual property is at the very, very heart of the museum's activities. As Laurent has rightly said, here we find a whole compendium of intellectual property. Museums' activities are related to copyright, to trademarks, to domain names, to industrial designs. I could even say that to patents sometimes. I've seen it, yeah. And certainly I think I recall that it was Laurent, you said something that I tried to memorize. Museums bring cultural knowledge to people. That's beautiful. Yeah. You didn't realize, but you have dealt with dozens of topics. Just recollect, just from memory. Museums as users of works, museums websites, catalogs, photographs, multimedia products. We have talked about digitalization, the commercialization of digitized works or products, merchandising, exhibitions, shops, access to reproductions, pictures. So many complex legal questions. Thank you very much. It has been very impressive. You have brought us the real world of what happens day by day in a museum. That's my conclusion. Yeah. I wonder whether this topic could not be the entrance door to anyone who would like to know about what is happening today in the museum's world. Yeah. So thank you very much, Ulrich. We really appreciate you moderator the skills. It was not easy, certainly, to govern this wonderful team, but you have done it very well. So thank you, well done. And there, Yolanda, there, Harris, we are also very grateful to you both. Be welcome to the Encounters family. Also, many thanks to Laurent, by the way. Yeah, thanks, my friend. I have the feeling that we could have spent hours and hours and hours moving from one issue to another, but believe me, you will be surprised when recognizing, when reading the report, the many questions you have brought on the table just in 1 hour. So many thanks to all those who have attended the encounter. We are always very, very grateful to your fidelity towards the encounters, and we do appreciate very much whatever advice, criticism, suggestion you can bring to us to improve the encounters. As also, now you know, after 27 encounters, we are convinced more and more that the whole body of encounters constitute indeed a very, very valuable legacy for the future, and it's a legal and valuable legacy that belongs to all of us. You will also have at your disposal the report in some days, and I would also like to thank especially Adele Serio and Javier Lopez Guzman, and they will prepare the report for all of us. So finally, thanks very much to 18. This has been very exciting having 18 with us. Thanks to FIDE and thanks to TIPSA, most especially, as every time say, thanks to Alvaro and to Blanca, and of course to all of you for being here today, for being so patient and for being so loyal to the encounters. So take care. Join us again in about 1 month. That's important. Don't leave yet. We do count on all of you for our next encounter. The next encounter will take place on the 22nd of June at 5:00 p.m. So be with us. We will discuss another fascinating topic, the interaction between designs and copyright in the digital society. Thanks for being here with us. Enjoy the rest of the day. Bye-bye.